Welcome back to Courtroom Breakdown. And today, you're about to witness one of the most emotionally charged cases we've covered. The defendant, Allison Lee Settle. A repeat offender with a deep history of substance abuse, past failures at rehab, and a strained relationship with her own mother, who also happens to be the victim in this case. But here's the twist. Settle is now a mother herself and claims she's turned her life around. The courtroom is split. The prosecution is pushing hard for prison, pointing to past failures, while the defense paints a picture of redemption. This case isn't just about guilt or innocence. It's about whether people can truly change. Judge Boyd has a reputation for being tough but fair, and you'll see him wrestle with this decision in real time. Will Allison get a second chance? Or will her past drag her back into the system? Let's break it all down.
State versus Allison Lee Settle. Can I have parties announced?
Hunter Morris for the state.
Will Brooks for the defendant, Ms. Settle.
Ms. Settle. All right. In the cause number ending in 9-0, you entered a plea of no contest to count one. According to the plea bargain agreement, punishment was to be assessed at a cap of 6 years in the prison. The state is opposed to your applications. And then, and the cause number ending in 240, you entered a plea of no contest to count one. According to the plea bargain agreement, there's a cap of 6 in the prison. The state is opposed to your application. Cases will run concurrently. Have both parties had a chance to review the PSI report, the TAP evaluation, and the MIC evaluation?
The state's reviewed them, Judge.
Yes, Your Honor. Defense has as well.
All right.
At this moment, the court is confirming the defendant's plea agreements, specifically that both charges carry a maximum cap of 6 years and would run concurrently. That means if she were sentenced to both, she'd serve them at the same time, not back to back. It's a big detail because it impacts how much actual time she could face. Notice how calmly both sides agree to the documents. No objections. But here's the kicker. Just because they agreed doesn't mean the judge has to follow that deal. What do you think? Should the judge honor the plea deal or go harsher based on her past? Let us know in the comments below.
Any objections to those documents, state?
None, Judge.
Defense?
No objections, Your Honor.
All right. State, do you have any witnesses?
No witnesses, Judge.
Defense, any witnesses?
Judge, I'd just like to call Ms. Settle briefly and inquire of her.
All right. Could you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right. You can lower your hand, state your name for the record.
Allison Lee Settle.
All right. Just make sure you keep your voice up so that I can hear and so that the court reporter can hear. All right.
Yes, ma'am.
All right. You may proceed.
Thank you, Judge. So, Allison, just briefly, you know what options the judge has today, right?
Yes.
And her decision is whether or not to grant your application for community supervision or send you to prison, right?
Correct.
Okay. When you got arrested for these offenses, you were pregnant, is that right?
Yes.
I'm sorry. What was the last question?
Since you were pregnant, Judge.
Okay.
Okay. Will you tell the court a little bit about what you did in jail after your arrest?
Yes. Well, because of my substance use issues, I was put in a medicated assistance treatment program that the jail provided starting when I got there. I also entered myself into the recovery in motion classes, which I completed. It's like cognitive behavioral therapy.
And when did you make the bond?
I made bond about 4.5 months after I was arrested.
And as condition making that bond, were you restricted in your movements?
Yes.
You have GPS, correct?
Yes.
And you currently have GPS, right?
Yes.
Where have you been living, Allison?
Right now I live at Haven for Hope.
Okay. And are you enrolled in programs at Haven for Hope? both substance abuse, parenting, and decision making.
And
Okay. Tell me about your baby. Where's the baby right now?
I recently got daycare assistance through being at Haven for Hope. She's at daycare right now.
Okay. Are you wanting the court to grant your application for probation?
Yes.
Do you have a problem with drugs?
Yes.
Are you ready to make some life changes? Okay. Maybe have a question before y'all pass the list.
Thank you,
Question?
Judge. Just wait briefly for the printer.
No.
Can you hear me okay? Okay. Ms. Settle,
Here's where the courtroom gets personal. Settle, who was pregnant at the time of her arrest, is now enrolled in rehab programs, living at Haven for Hope, and caring for her baby. She's pleading for probation, and you can hear the vulnerability in her voice. But beneath the surface, there's tension. This isn't her first time asking for help. In fact, the court previously gave her the chance to turn her life around, and she blew it. Now she says this time is different. Is motherhood enough to keep her clean? Or is this another empty promise? The stakes couldn't be higher for her and for her child.
you were here in 2021 before this court, weren't you?
Yes.
Before this judge, asking for probation,
Yes.
asking for treatment. Did you get treatment?
Yes.
You were in Esperanza court, weren't you? You were ordered safe P.
Yes.
And when you were in jail on that case, you were pregnant or just had a child, right? And did you complete that probation successfully?
No.
What happened?
Well, I've lost custody of my child and I went back to doing drugs.
How is this situation different from that situation?
I currently have custody of my baby and it's been a big motivation to continue on the right path.
Did you ever go to Safe P?
Yes.
Now, and in the interview with the PSI officer, you noted that you just happened to have those items belonging to your mom because she was a realtor and that she picks up mail from various clients. That's the only reason you had them? They just happened to be in there?
I shouldn't have had them.
I'm sorry, I can't hear.
I shouldn't have had them and I did.
But you didn't just happen to have them, did you? You took the bags that they were in
Right.
from your mom's house.
Right.
And that gun was stolen.
Yes.
No additional questions, Judge.
All right.
Just argument, Your Honor.
All right, I'll hear argument.
State reserves, Judge.
All right, well, let's do this. Let's reserve argument because,
And here it is. The moment that pulls the rug out from under her defense. Settle claims she just happened to have bags that didn't belong to her. But under questioning, it's revealed she took them from her mother's home. And yes, the gun inside was stolen. This is where credibility collapses. She says she shouldn't have had them, but she did. And not by accident. That's a felony offense. And a huge red flag when you're asking for leniency. Would you trust someone on probation who's still dodging the truth in open court?
I've heard the testimony from all parties. I'm going to have y'all come back at 1:30 and I'll make my decision at that time. And then y'all can make your arguments and I may have some more questions. All right, they're just things that I need to think about with regards to this case.
1:30, Judge?
Yes.
Yes, ma'am.
All right, thank you.
Thank you, Judge.
Thank you.
Thank you.
All right, Mike Hernandez,
3 days later.
State versus Elizabeth Settle. Can I have parties announced for the record?
Hunter Morris for the state.
Will Brooks for the defendant, Judge.
All right, and you're Miss Settle? All right, we were here on July 28th. The court ordered you to have a drug testing done, and that was completed. Is that correct?
Yes, Your Honor.
And what were the results?
So she was positive, Your Honor, but it was for her medication-assisted treatment. There was nothing else, no other substances.
All right. So the other reason why I had this case recalled back, because this is actually a tough case, right? And it's a tough case. And when you read it on the surface, you should be going to prison. But then there are other things for me to consider as well. The fact that you have a child and it appears that you have changed your life, and defense, I believe yesterday you said that she was being accepted into felony drug court.
Yes, Judge, and also I had some argument for the court too. The court was ready, but that is correct, Judge. She was screened for felony drug court. They did not accept her because at the time she had not been sentenced. But I verified with felony drug court that should she be placed on probation, they are able to accept her and can squeeze her in next week.
All right, so state.
Yes, Judge.
I understand why the reason you're asking for prison time. I do, and I want.
You can feel the weight in Judge Boyd's voice here. On paper, he says, this case screams prison. But he's not ruling on paper. He's ruling on people. He notes Settle now has a child, appears to have changed, and is on track for felony drug court. But the elephant in the room is her history. She failed probation before, and even her own mother, the victim, is torn between hope and exhaustion. This is a powerful reminder of what judges wrestle with: the law, the facts, and the humanity behind both. Would you take the risk and give her probation?
You, Ms. Settle, to internalize what I'm saying. What I'm considering is the fact that she has a child. It appears that she has changed. Sometimes it takes people a long time to have a wake-up call. I still don't understand why you keep having children when your life is not where it should be. But usually when people are addicted to drugs, they're not thinking appropriately to begin with. They're not thinking about the future. They're not thinking about how their drug use will impact everyone else. And state on this case, I see that you're asking for a cap of 6 years in the prison. And one case is a second-degree felony. And the other case is a third-degree felony. And I'm assuming she has restitution to pay?
If it isn't included in that plea bargain right there, Judge, then no certain amount.
All right. So we're going to see the amount of restitution, and state you've had a chance to hear her testimony. Are you still going to be requesting prison time?
Judge, the position of the state is that this offer was made considering the history, the knowledge that Ms. Settle has been before this court previously, also with a new child, asking for the same type of leniency and treatment, and was offered that leniency and treatment and turned it down and returned directly to that life. And so it's not just Ms. Settle the state is concerned about, but it's Ms. Settle's children, it's Ms. Settle's family, and it's Ms. Settle's community, many of which were victims of Ms. Settle. And that is the reason the state is opposed. But the state is cognizant of what appears to be genuine changes in Ms. Settle's life.
All right. And I know that this involves her mother.
Yes, Judge. So the world is an ironic place. It turns out I'm appointed to represent Miss Settle, but I have known Miss Settle since she was about knee high. I've known the complainant, her mother, and also her brother, who's referenced in the PSI, someone that I went to high school with, was close friends with. Mm-hmm. So I've known this family a long time. I've spoken to the complainant, to her mother, Judge. Mm-hmm. She is certainly at wit's end with Miss Settle. She's spent a great deal of money helping her out, trying to get her on her feet. But it is also clear in the PSI that she is seeing and she's witnessed some of the changes that Miss Settle has made in her life and has made. And the question came up yesterday, Judge, what's different or what's changed? Mm-hmm. And I think the distinction between this time and last time she did not do what she was supposed to do for you, Judge. It's very clear in the PSI back in 2020, they were going for things. She was released from the jail accidentally. She skipped out on GPS. There were all sorts of issues, Judge. In this instance, since both when she was arrested and then certainly after being released on bond, she's made great strides to try and do what she's supposed to do. She's been on GPS. She's been compliant. She's been enrolling programs. She's tried to be a parent to her mother or to her child. She's also shown up here today, Judge. She's not run off. She's not fled. She's not skipping out on things. And when you're talking about therapeutic justice, Judge, when someone's an addict, there's no such thing as a cure. But it seems to me like she's trying to make some legitimate life changes. And I think society and Miss Settle would be served better by trying to get her some therapeutic justice and trying to continue her down this path rather than sending her to prison again. PSI, the complainants themselves don't indicate that they'd like Miss Settle to go to jail, prison. Her mother certainly would like Miss Settle to have the threat of prison or jail time hanging over her head, which is something I think is a great motivator a lot of times. So for those reasons, Judge, we're asking the court to consider probation or community supervision in some form in order into the drug court program.
All right, anything you wish to add, State?
Judge, the state stands by its concern about Ms. Settle being a good probationer, a good candidate for probation. That being said, the emphasis from the complainants was that if this court were to grant supervision, the state would ask for very structured supervision, because I do believe that it is a necessity in Ms. Settle's life at this point. I believe drug court would be appropriate and, if needed, inpatient treatment.
All right. So the court is going to give you a choice. Some people say my probation is very difficult. I'm sure you're aware of that, as I've sentenced you before for not doing what you're supposed to do. I'm going to give you a choice. I can sentence you today, and I will sentence you to 3 years in the prison. Otherwise, the plea negotiation needs to be reworked. And by that, this is what I mean. The case that's a second-degree felony.
Now this is rare. Judge Boyd flips the script and gives Settle a choice. Take a 3-year prison sentence or accept probation with serious consequences. Here's the breakdown. For the second-degree felony, a deferred adjudication. If she messes up to 20 years. For the third-degree felony, a 10-year conviction, suspended. If she slips, 10 years in prison. This isn't leniency. It's a tightrope. One slip and it's over. Why would the judge structure it this way? Because it puts total control and total responsibility on Settle. It's now completely up to her.
I will give you deferred adjudication. And if you were revoked, you're looking at 20 years in the prison. Do you understand?
Sure.
And then on the case that's a third-degree felony, I would convict you, but I want the underlying to be 10 years. So you can discuss that with your attorney.
Judge, you'd like the opportunity for probation, Your Honor?
All right, so normally, legally and ethically, I'm not allowed to interfere with negotiations. But what I'm telling you and telling your client, on the cap of 6 offer, for me to request that it be an underlying of a cap of 10, that's changing your plea negotiations. And if you want a jury trial on that, you can have a jury trial on that. Do you understand?
Yes, sure.
All right.
Judge, on the second-degree case,
Mhm.
is there no application for deferred indicated in that plea bargain agreement?
On that one, let me see. No, it just says that you're all opposed to community supervision in deferred adjudication, but I do have an application for deferred adjudication on that case. And on the firearm case, there is again, there's the state is opposed, but there is an application for deferred on that case.
Okay. So the only one we would need to change is the one with the conviction, so the third degree.
Yes.
This court could give them 10 years deferred on a cap of 6. Opposed.
Well, no, on the we're off the record, on the unlawful possession, the court wants a conviction on that case.
Okay.
So there will be guilty, but I want her underlying to be the 10 years.
Understood.
And then on the other case at the second degree, I'll give her the deferred adjudication. So the reason why I'm doing that is because then on both cases, you will be subject to the full range of punishment if you were revoked. Do you understand?
Yes.
Understood, Judge.
So if you all want to change that to a cap of 10 and state, I'll still note that you're opposed.
Yes, ma'am.
The court is going to grant your application for deferred adjudication. Court is going to sentence you to 10 years deferred adjudication. There's to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. This is to run concurrent with 2024 CR 013090. With regards to this, no harmful or injurious contact with KPEC and family. And then there's no contact with Linda Vargas, Destiny Thurston, Juan Uriega.
Uriega, Judge.
Yeah, thank you. I look at Deputy Laura because she's like, I'm trying to teach you. David Getz, Goetz, or Dick Creamer. And there'll be restitution, if any, to all complainants. If there's an issue with the restitution amount, we can have a restitution hearing. And Ms. Ferguson, can you set this in 45 days for restitution hearing, please? In case there is any.
Fair enough.
All right, what date? All right, we're going to come back on September 11th and state this just to see if there's any restitution amount that's owed. And we'll have a restitution hearing on that day.
Yes, ma'am.
There's to be 200 hours of community service restitution. I'm going to order parenting classes. Once that's complete, 100 hours will be deemed satisfied. There's $1,000 fine that will be probated. And there's to be a referral to felony drug court. If for some reason she's not accepted in a felony drug court, she's to come back to this court. However, counsel has informed me she has been accepted. And there's to be continued GPS until further notice. Probation, is there anything else with regards to that sentencing?
Yes. Are you waiting?
Yes.
And can you please, no contact, did you say no harmful or injurious?
No harmful or injurious contact with PECK, PECK, and family. And then there's to be no contact with Linda Vargas, Destiny Thurston, THURSTEN, Juan Uriega, David Getz, GOETZ, and Dick Creamer, and Rudy Rodriguez.
Judge, to put a fly in the ointment, Mr. Rodriguez is actually the child's father.
I'm just going by what's in the plea paperwork. So that's something that will need to be addressed with Judge Glenn. Probation, is there anything else? Anything else with regards to sentencing in that cause number, counsel?
Nothing from the state, Judge.
Nothing from defense.
All right, the court is going to sentence you, the court is going to find you guilty. The court is going to sentence you to 10 years in the prison, suspended and probated for 10 years. There's to be regular reporting by Zoom or in person. Case has been cleared and you're finally going to do what needs to be done. In each of these cases, In one case, you're looking at 20 years if you're revoked. In the other case, you're looking at 10 years if you're revoked. So from here on out, everything you do, you need to ask yourself two questions. Is this something that could potentially result in me being revoked? If the answer is yes, don't do it. If the answer is maybe, don't do it. If there's anything else that's in between, you need to contact your attorney. Do you understand? All right. And if you're not going to do it for yourself, you need to do it for your child. All right. Thank you, counsel. Thank you.
Thank you,
Thank
Judge.
you. It's always great seeing both of you guys.
Me too, Judge.
All right. Thank you. So Hunter, how's it been going?
And there it is. The court grants probation, but with massive strings attached. Regular reporting, parenting classes, drug court, restitution, strict no-contact orders, and worst of all, one misstep could cost her up to 20 years. Judge Boyd's final words hit hard. If you're not going to do it for yourself, do it for your child. This wasn't just a sentencing. It was a warning. A final chance wrapped in accountability, whether she seizes it or throws it away. Only time will tell. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns. We're just getting started.